And we are now live. Now, we've had quite a few technical issues this evening, and we decided, would we or would we not go? Believe it or not, I'm being joined from the centre of our capital city by the Master of the High Court, Edmund Honohan, but we are having Wi-Fi problems. And, you know, this sort of sums up everything that's wrong with Ireland. We can't even get a proper Wi-Fi signal from the centre of the capital city. But we've made a decision to go ahead with this, and Edmund has very kindly agreed to come back if we feel the sound quality isn't up to scratch, but we're going to go with it anyway. Now,
plausible deniability anyway. If somebody says I said something which defamed, I can say, oh no, you must have misheard.
Plausible deniability is always a good thing. Edmund, welcome to my live stream. I'm really pleased that you've joined me this evening, and we're going to be discussing the worsening housing crisis in the country, the sellout of Ireland to foreign vulture funds, and the tsunami of evictions and repossessions and debt that you're having to deal with in your court in Dublin. Now, I want to say, first of all, that Edmund stands out in his profession, and he is a shining light. I've been in his court, and it is one of the few courts in this country that I believe is administering justice fairly at the moment. It's not a pretty sight. I would encourage anyone who is in the comfort of their own home, who is not facing appalling debt arrears or is under pressure from a vulture fund, I would encourage anyone to go into Edmund's court any day of the week, and you will see the housing crisis and the debt crisis and austerity in full technicolor in there. Edmund, would you just give us a rundown of what you're dealing with? And we're going to talk through exactly what you feel the solutions are, the new legislation that you have written recently, and where you see the solutions, as I say. But first of all, just talk me through what a typical day in your court is like.
Well, I think first of all, I have to explain exactly why people have to come to court, because it's a little unclear. When a person ceases to make a payment on a mortgage debt, that triggers the mortgagees, that's to say the lender or the bank, right to sell the property. That the default has occurred and the mortgagee has the right to sell. Now, that's it. The person living in the house has now become a squatter. They no longer have title. Title has in fact been extinguished effectively. But the courts require the lender to come before it in the case of a home loan and apply for an order for possession. And that's become known as a repossession because of the history of hire purchase, the repossessions of cars and things like that. The word repossession is in the lingo, but nevertheless, it's an order for possession, and it's a discretionary order which the court can make. And in the earlier cases, well, in the early part of this century, the courts were very clear that the possession order wouldn't be made as a matter of course. That's the phrase used. In other words, it wasn't automatic. You just didn't get a rubber stamp on it. You had to actually make out a case that you, as lender, should be given the keys of the property in order to complete the repayment of the loan by selling the property. So there was a discretionary order applied for, and the court would make an order accordingly. Now, when the crash came here, it happened to be the case that all of the mortgages that went into arrears started to come up to my court, because I'm the, if you like, the gateway to the High Court. They all came up to me, and it was horrendous. We had a horrendous couple of years when there were people coming up saying, I'm sorry my husband isn't here because he committed suicide last June, this kind of stuff. It was really horrific. And eventually, after some loud noises from myself, the Minister for Justice at the time, Alan Shatter, decided that it wasn't right to have all these cases coming in before Dublin Court, and that he would allow the Circuit Court a jurisdiction to deal with them in relation to home loans. And for that reason, then they disappeared from my court, and I'm now left with a very unique set of cases in the repossession list. And those are cases where individuals who have lost in the circuit court for whatever reason, and then have omitted or failed to appeal within the 10 days that they're entitled to lodge an appeal, have to come into me and say, any chance you might let me into the High Court for an appeal? That's a very straightforward application. You might think, oh, it's like getting a ticket for a printout or buying a new passport or something like that, but it's not, because the High Court is very assiduous about guarding its own workload. And the High Court says we really shouldn't be hearing these late appeals, because there has been a decision, a circuit court has made a decision, and that's it. You know, why should a person be entitled to rake up an old case and say, let's have another go? And the Supreme Court has made several pronouncements over the years as to what factors have to be taken into account. Now, they're not the factors which concern the instant case, if I put it that way. That's to say the repossession and the default and so on and so forth. There are other factors. So we embark on an analysis of, which is somewhat surreal, about other matters, like, well, why did you miss the deadline? Did you know there was a deadline? What's your excuse? And also a variety of things comes into me, and then you have to decide. Ultimately, you have to decide if we do leave open the possibility of an appeal, what are your chances of winning? Now, that involves me and the court looking at the papers to see whether or not there's a chance that the defendant might win the case. Mm-hmm. And recently, I've come to the conclusion that that the stories I hear from the circuit courts all around the country, and I'm not criticizing anybody in particular, the stories I hear are of very summary, unfeeling court hearings at which the defendants are not really allowed an opportunity to lay out their stall. And some of the stories are horrendous, but of course, I don't. Well,
I want you to discuss those with me. But first of all, I mean, having spent some time in your court recently, it struck me that you have so many citizens, ordinary citizens in there representing themselves, lay litigants, who appear to have absolutely, and why should they have any awareness or knowledge of the law? Then on the other side, you have teams of what appear to be mainly young barristers representing the banks. And some of them don't seem to know the law either. And you're stuck in the middle, trying to deal with poor citizens who are, you know, at their wits' end, losing the roof above their heads. Not all of them deserve necessarily possibly to even be in there. Some of them are there due to their own mistakes, but many of them are not. Yeah. But that is what is so striking. You know, the banks are, as they say, lawyered up to the gills. Mm-hmm. With, you know, most of the barristers I saw in there seem to be fairly young. It seems to be they're sending in, you know, the younger crew. It's nearly as if they're afraid to send the big guns in, because the work to me appears to be the lower end of the scale in terms of, you know, why do you go into the law? Is it to throw citizens out of their homes? But answer that, Edmund.
No, the lawyers that come into my court are in their first few years of practice, and it is practice. I mean, we call it practice in the sense that they're building a professional career, but they're actually learning the skills of the trade. So it's often the case that I might have a discussion with the lawyers, which is way over the heads of the lay litigants. It's for the purposes of me pointing out how the lawyer can improve the case, or when he has in fact not made the case as he ought to. There's a very interesting feature of the legal system, which you're probably not aware of, but just thinking about it logically, you'll realize that it makes an awful lot of sense. That is to say, judges are not expected to know the law. Yeah, see, that surprises you. Well, there's a reality, of course. Some judges know a lot of law, some judges know a little law. But the end of the case should be a judgment which is based on the law, the whole of the law. And in order to ensure that there's a consistency between judges, where is the judge to get his law? Who is to inform him of the law? And the answer is the barrister. the barrister has a duty to the court as well as to his client. And he's supposed to come into court and say, on the one hand, there's this case and this case, which is in my favor. But on the other hand, I have to tell you, Judge, there's another case which is against me. So the judge then gets a full picture of the legal position, the context in which he must make his decision. So I have no problem with lawyers coming in and me having to haul them over the coals if they make mistakes and so on and so forth. It's all helping ultimately towards ensuring that justice is done in these cases, because these cases, if they move from my court, will go on downstairs, and the points that I will have highlighted will then be ventilated before the High Court judge. As regards the lay litigant, the difficulty is that he usually comes to court thinking, well, if he's told his wife, that's one problem. There are men who come and say, this is terrible, I haven't even told her yet. And you have to have regard for these. This is a critical situation from a family's point of view. But they'll come in and they'll say, well, I don't really know. I just want to negotiate. And they don't know the law for starters, but they don't even put the facts down in an affidavit form. So you end up having to say to them, when did you buy the house? How did you fall into arrears? What's the story there? Who else is living in the house? And often when you explore these on a man-to-man basis, if I can put it that way, you begin to get a real feel for the crisis that's around the country. That seems to me to be the true measure of a court, that an individual who's facing eviction should be allowed an opportunity to not just look at the legal position, but also to explain where he is in life, in his life journey. And it's often at that point that you begin to realize that there are so many other people affected by the decision that it becomes necessary then to consider, as I did recently, whether or not it can be safely concluded that the circuit court hearing, which they want to appeal from, was a fair hearing. Was it completely fair? Did they get an opportunity to present any sort of a case, or were they simply told to sit down? And often they misunderstand what the judge says, and they come into me and with them horrific stories. But often the judge might well have been right in what she did or he did. But at the same time, if anybody walks out of a court saying to himself, I didn't get a fair hearing, that's a bad day for justice. Mm-hmm. And I form the view that no matter what the likely outcome is going to be, that person should at least be given another opportunity before a High Court judge to make whatever case he can. And that's for that reason. We're here now. We're talking about the European Convention of Human Rights. This is it's Article 6. I don't know. Most of your viewers would probably not know that Ireland, as a country, as a nation, was hauled before the European Court in one of the earliest cases. This is the Court of Human Rights now, not the European Community Court. Court of Human Rights, and it was Mrs. Robinson, it was Mary Robinson actually, who brought the case on behalf of Mrs. Airy, and Mrs. Airy had run her own separation proceedings in the High Court, and Mary Robinson took the case anyway to Europe, and she said this woman really should have received legal aid from the state, and the court agreed. They said if any case involved complexities which a layperson couldn't effectively participate, was a case in which the state had an obligation to provide legal aid. Now, wind on 40 years, and what we have now is an acknowledgement, passing acknowledgement by the government, if you like to put it this way, in the Awalia scheme. They'll say, oh, well, in case we get hauled before the European Court again, we'd like to be able to go in and say, oh, well, there's the Awalia scheme, and there's €200 worth of legal aid there. And sure, that's as much as they need because they're going to lose the case anyway.
That basically is the Awalia scheme in a nutshell. That it's €200 worth of legal advice.
Advice, yeah. Not even. It's advice. Often it's advice. I remember one lady came to me and she said, "I lost the case in. I won't mention the circuit court and." I was talking to the Awalia person afterwards, and I asked him, what should I do? And he said, well, the only thing I can recommend is go and marry a rich man. And but at least she had the opportunity of telling me that, which I think was important for her. She obviously was aggrieved about that, and she got the opportunity to tell me. So she obviously got permission to appeal. The legal aid available under the Awalia scheme is really a read through of the papers, and I don't know whether you noticed that when you were in my court, I read the papers, and they often contain mistakes, quite huge mistakes. There was a previous master, Master Paddy Lindsay, who was TD and a Minister of Gaeltacht at one stage, and he wrote his autobiography. I'm not going to write an autobiography, right? But in his autobiography, he said, when I was the master, he said, I used to ask the practitioners, were their papers in order? And I believe it was on only one occasion, he said, I was let down by their response. But in fact, I find that on reading the papers, you find the most horrendous mistakes. And the lawyers for the banks and the lenders are extremely annoyed when I point out they have. I had a case there last week where the banking deponent said that the defendant had signed a mortgage of property XYZ, and he described it. And when I looked at the mortgage deed, which is attached to it, I discovered that this was not the case. He had, in fact, mortgaged the property X and Y, but not Z. The words Z had been added to the description of the mortgage in the affidavit. And this sort of, I mean, you might say, it's just a slight mistake or an inaccuracy on that. But my view is, if the lawyers can't get the papers right, how do you expect the lay litigants to be able to effectively participate? You know, that's. And
I mean, Edmund, this is why this conversation is so important, and it's so important for you to speak out as a barrister. You're not a judge, but you I suppose it's a quasi-judicial role that you have. But, you know, I think a lot of the problems in relation to the housing crisis and evictions and repossessions in particular goes back to the quality of our legal profession. Because you've made the point that the law is there, but unfortunately, these lawyers that we are producing out of our universities, I mean, goodness knows we produce enough of them. And yet they do not seem to be able to interpret the law, to fight for citizens, to have the will, the desire to fight for citizens' rights. And yet they seem to queue up to represent the banks. And I wonder, is part of this to do with the fact that many in your profession and mine got carried away during the boom, the last crash, and found themselves in a position whereby they were not able to maintain their lifestyles, and they're nearly having to sell their souls at this stage and work with these banks that have absolutely no shame, who are the reason our country is in the mess that it is in, and yet so many members of our legal profession are working with them. Am I being unfair?
Probably being unfair, yes. If the lay litigants had the wherewithal to engage the barristers, I'm sure they would put up a decent fight on their behalf. I think we have had many of the cases that have been taken on, if you like, by pro bono lawyers have gone all the way up to the Supreme Court. And these are the only cases which have, if you like, rattled the foundations of the lenders to the point where they're now selling off their portfolios. And the title of the lenders, you had some very arcane decisions about the Property Registration Authority and the difficulties with transferring mortgages and the new redacted documentation and so on and so forth. All this is very interesting to a professional lawyer, but of no use to a lay litigant.
But Edmund, why are so many people ending up lay litigants? Why is it that they can't go to their local solicitor and say, look, this is happening, what's the story? So many people come to me and say, I don't trust my solicitor. It seems my solicitor is working for the other side. And you know, I have to say that has been my experience working with lawyers in this country, that there's so few of them that are willing to stand up for the citizen take. And I understand that the costs can be huge.
Well, it's not just the costs, but unfortunately, it's also the prospect of, you know, losing in the circuit court, appealing to the High Court, taking it from there to the Court of Appeal, and if necessary, on to the Supreme Court. And the solicitor is tearing his hair out saying, this client has no money. And I could spend my entire life dealing with cases for clients who have no money. Sympathetic though I might be to their position, all I can do is to say, you'd be better off to try and negotiate. And commercially speaking, they're probably right there. The difficulty now is that the portfolios are now being transferred. There's an interesting thing here, Gemma, that's to say we've reached a certain point in the history of the state where the banks have been sorted or are just about to be sorted. And up until this point, some people have said to me that the impression they had was that the judges were, if you like, wearing the green jersey. They were saying, oh, the banks will have to get their orders. We don't care if there are any technical defects here or if there's a T not crossed or an I not dotted. The banks are going to have to get their orders because the bank's balance sheets need to be corrected. But the same kind of, pass, I call it that way, the same presumed credibility of bank evidence does not apply to the vulture funds. So they're going to come into court saying, oh, look, we bought this farm for 100,000 and he owes 500,000 on it, so can't he give us the farm? And they can expect a much tougher examination of the paperwork. Because in America now, and it's a pity we don't have the American professor with us tonight, but in America, there's no difficulty at all in a court throwing out security documentation and saying, that's rubbish, shred it, it's not worth the paper it's written on. And yet here we seem to be, at least up until now, we seem to have been bending over backwards with the Tipp-Ex pen to make the necessary corrections to ensure that everything moved through without a hitch. Mm-hmm. Mm-hmm. I think one of the reasons we got into this was a failure to realize that we had an insolvency problem. So government policy is based on a kind of very superficial approach. They say, oh well, we'll try and keep as many people in their homes as possible, and that's a glib attitude. There are people who have moved on in life. It's astonishing the number of cases I get from one particular bank who come in and they say, well, we want to repossess this property, and you say, well, where's the defendant? Oh, the defendant's gone to Australia. And sometimes it's 5 years vacant property and 6 years vacant property. They have a little memorandum from somebody. The neighbors say, we haven't seen him for 6 years, and the grass is so knee high. And this kind of thing it should be dealt with fairly quickly. In fact, there is a provision in the 2009 Act for abandoned properties to be taken into possession by order of the district court, and you can imagine that would be an instant boost to the homeless situation.
And what percentage of cases would involve that?
Quite significant. It might be 15%.
People are literally just abandoning their homes because they can't afford them probably anymore.
Or there's been a marriage breakup, or they've whatever, they moved back with the parents and all. And this happened 4, 5, 6 years ago. And they've been vacant since. And so I don't know whether they fall into the category of vacant properties that everybody says should be made available for rehousing social housing tenants. But in any event, the point I'm making is that the government's policy, which is keep people in their homes, the difficulty is there is a group out there who say, why should we? Because they didn't pay the mortgage. See, they shouldn't be entitled to stay in their homes if they didn't pay their mortgage. And they look at the bill that I've drafted and they say, that's giving a real gift, a windfall to people who didn't pay their mortgage. And they say, that's not right, it's not fair. But in fact, the bill provides not that people should retain ownership of the house, but that they would become tenants of the house in the scheme that the government itself introduced, which was the mortgage to rent scheme. That was the proposition put forward by the Keane report. They said mortgage to rent is the way to facilitate families living on in their homes as tenants from now on. And the bill that I've drafted really is about rolling that out on an industrial scale, which is what's required. And when it was originally presented, Deputy McGuinness said that what we needed was I think he described it as a friendly vulture fund. And when I was asked then to throw my eye over that, I came up with the idea of a housing cooperative, a national housing cooperative, which would then access international money on the international markets. And the proposal was fairly well formulated, and people in Ireland just don't know about the international movement in cooperative, particularly in housing cooperatives, particularly in Europe, funnily enough, where huge percentages of people live in cooperative housing.
Mm-hmm. And I want you to explain that in very clear detail. But just getting back to that point, when you're trying to explain to people who are not affected, at least they think they're not affected by the housing crisis, and they say that's not fair. Well, what would they rather? Would they rather their taxes going into keeping people in hotels, putting families with young children into hotels, into hostels, in very vulnerable situations, which is going to maybe result in an increase in crime, in social breakdown? Or would they rather their taxes went on keeping families in their homes? I mean, how do you persuade people around that idea, Ed?
You tell them you don't pretend that the government will be able to accommodate all these people if and when they're evicted. You don't say, well, that'll be the government's problem. It won't affect us here. And the impact on tax, that's not really considered at all. I mean, you have Mel Reynolds has done some analysis for the impact on the budget of huge numbers of additional HAP tenants being created as a result of people being evicted or losing their homes. And forget about Brexit. This is a real problem, in terms of finance. There's one other thing I wanted to mention as well, and that is that in all of this analysis, people say, oh, well, it's the family homes, the home loans, they're the ones that we have to look after. But the rental properties are not coming through the court. If somebody owns a rental property, if an investor owns a rental property and he fails to make his payments, what happens is the bank or the lender will appoint a receiver outside of the court. There'll be no court process. The receiver will then write to the tenant and say, "Get the game's up, you have to leave." And these are predominantly the source from which the current homeless figures are emerging. And again, there seems to me to be a failure on the part of the government to take appropriate action in relation to protecting tenants in such a situation. And the bill also includes a provision to ensure that, and it's the key provision in the bill, which is to ensure that people who are entitled to remain in possession until and unless the property is actually sold. That's to say, until the keys are actually being handed over to the new owner. Then it's a matter for the new owner to decide. That's, in other words, more or less the same as with any commercial property. So simply treating a buy.
Well, I mean, obviously this has nothing to do with the fact that 1 in 3 TDs, I think it is a landlord. I mean, it's quite obvious that there is serious protection for the landlord class in Ireland. But we all know that.
A little bit glib, if I can put it that way. This whole exercise is about refloating the banking system. When the banking system crashed, we set up a bad bank. The bad bank took the worst of the loans, the heavy stuff, and instead of holding it and managing it as they were required to do, where Brian Lenihan spoke at that time about the social dividend, instead of that, the decision was made by, I think, Minister Noonan to get foreign capital in by offering incentives in terms of capital gains tax breaks and so forth. And so the commercial market started to lift when they sold commercial properties, and the same drive to push up the value of residential properties was approved, was sanctioned, if you like. But the government didn't say this is why we're doing it. They simply said, oh well, this is what's happening. We're just trying to deal with things. The world is in a difficult situation, and we have to take it as it comes. Mm-hmm. The deliberate decision made. As a matter of fact, I brought something in actually. I thought it was quite interesting. I thought you'd be amused with this. This is astonishing. This is a report in the Business Post of July 2018. I'll read the bit. Mm-hmm. It has emerged that the Department of Housing edited the conclusions of a housing agency report to downplay recommendations that the state, through local and regional authorities, should set plans for house building rather than leaving it to private builders. Documents seen by the Sunday Business Post show that a month-long editing process between officials from the two bodies resulted in the removal of a conclusions section that emphasized a deeper study of other European countries, specifically the Netherlands, where local and regional authorities are at the forefront of national house building strategy. That's an astonishing piece of information that came out, and it serves to confirm that there's a strict agenda set by government, perhaps misguidedly, perhaps unthinkingly, and ministers are trotted out regularly to defend the position and say, just go, say whatever comes to mind and stick to it. Even yesterday, we had a minister who told us that, maybe it wasn't a minister, she told us that there couldn't be any rent caps because of the accidental landlords phenomenon, and also because of the constitutional provisions in relation to the private property rights. Well, this was one of the things that actually enraged me at the time. As I say, when Alan Kelly, when he was then Minister for the Environment, was actually attempting to spancel the private rental market, he was told apparently by the Attorney General at the time, you could forget it, it's unconstitutional. And yet his successor then was allowed to go ahead and put in rent I don't know what they call them, zones, rent limited zones. And there's absolutely no reason why a government policy in relation to rental properties shouldn't be a great deal more aggressive in relation to the marketplace, because the cost of not doing it in terms of having to rehouse people who are on dodgy tenancies is huge. And so that in itself is the formula for the common good, which the Constitution allows to be taken into account in factoring in whether or not interference with a right is proportionate.
Yes, but of course the common good is usually secondary. In fact, it doesn't seem to be relevant at all to any of the political parties at the moment. But just getting back to
one of the problems there is that the Constitution itself doesn't specify the common good as being a fundamental right. It's mentioned in several places, and in fact it's in the overall ethos of the Constitution, and you can read between the lines that it's the common good which, if you like, was declared in the by the first Dáil, the property, the ownership of the property of Ireland, and the 1916 Declaration, and even in New York, which is something I discovered in the early 20s. In New York, this is the home of capitalism. They imposed rent controls. This is because of returning troops from America had started to push up the rents that were being demanded. So the Americans are just laughing at us. Actually, this is a pity now that I don't have the American professor tonight, because it was one of the things I wanted to discuss with them. They have this mechanism called eminent domain, which is the same thing as compulsory purchase orders. The domain, that's to say the estate or interest of the state, is eminent. It's preeminent, in other words. And at any point in time, a state legislature can say, right, well, that parkland there is now going to be state property, and there's very little that the owners can do. They simply say, well, pay us the compensation and we'll go away.
But I mean, Edmund, you're working on the assumption that the powers that be in this country are actually going to do the right thing at some point in the future, which they're not going to do. Well, they're not going to do it because A, they don't have a conscience. It's quite clear. They seem to hate the Irish public. They don't care about the people who are in need, who are losing their homes. But also, they are, even if they found their conscience in the morning and said, actually, there is quite a lot of suffering going on, we can't have people homeless in, one of the richest countries in the world. They can't, even if they decide that they want to do that, because they're controlled by vested interests. So, all the legislation in the world is not going to be implemented by these corrupt individuals running our country who have no conscience.
Well, I don't have an ideology here that comes to play, because being a lawyer, you look at things strictly from the legal position, and you look to see whether or not the law has answers. And when the guys came to me and said, we need a friendly vulture fund proposal, I constructed the proposal in a way that it comes within the law. It's perfectly manageable. It's quite an interesting structure, which maybe I should explain.
Just so I can explain, this is the Right to Homes organization run by Brian Riley, and they are doing great work to try to keep people in their homes, and they're trying to take on the corrupt system, which is difficult, and you're hitting your head off a brick wall the whole time. But just explain exactly what it is you're trying to do.
Yeah, let's see now. In order to keep people in their homes, the homes should be sold not to vulture funds, but to some not-for-profit organization. Now, in order for that to happen, the not-for-profit organization, A, needs money, and B, needs access to the market so that they can actually bid for the homes. So if you've got a situation where a bank decides to sell a portfolio, and what it does is it says, we're opening the data room, and you can go in if you write a big check. Mm-hmm. Then you can decide whether or not the portfolio is worth bidding for. Now, no charity is in a position to come before the owners of the keys of the data room and say, we've got a check to cover it. So they're excluded from the process of sale. The big windfalls will inure to the vulture funds who buy from the banks. And that's the way the system has been structured. I have my own view about that, incidentally. I think that the arrangements under which the vulture funds got the green light amount, in fact, to illegal state aid under the community rules, because they're creating a distorted marketplace, which prevents the not-for-profit bodies, and indeed prevents the individual mortgagors from bidding for their own property. So in any event, that's you have to create a market, and to create that market, there's a requirement in the rule that any property that's being sold, a loan that's being sold, or a mortgage property that's being sold, will be notified on an internet site being run by the trusts, I can't remember now what they're called. The friendly societies, the registrar of friendly societies. So he'll run the site, and it'll be posted up on the site, and anybody can make a bid. It's listed. There are listed charities and not-for-profit organizations, and local authorities are even listed there, and they can throw in a bid. And that bid is known as, just by way of a neat phrase, it's known as the non-compulsory purchase order, in order to emphasize the fact that it's not compulsory, so it can be rejected. So the bank can say, no, we're rejecting that. But if they do reject it, they're then required to sell the property through the court system, which they don't like. At the moment, as I say, with the buy-to-lets, it goes into a receiver, the receiver sells. Now, if it has to go into the court system, and there's absolutely no reason in the world why that would be regarded as an interference with the property right, because throughout Europe, this is how repossessed properties are sold, through a court. If you ever go on holidays to Europe and open a paper, you see a half-page ad in small print. You see about 70 different properties identified, and details of where they can be found, and so on and so forth. That's a court sale taking place. Now, that's what can be done here without interfering with the property rights of the bank. So they're now stuck with going through that process. And ultimately, that process will take quite a while, because for some strange reason, courts tend to work rather slowly. And this process would take some time, during which the tenants would be allowed to stay. So now the banks have to say, well, I don't know, this doesn't look like a very commercial property here. If I'm a vulture fund and I'm selling a portion of my portfolio, which they may be doing shortly, they're saying, well, hold on, we intended to flip this in 2 years or 4 years. And now we've got this new mechanism which says that if we want to sell on, we have to go through the non-compulsory purchase order stage. And then we have to go in through the court stage. And they'll take the commercial route, and they'll say, let's look again at that offer from the not-for-profit body. And maybe that's where we should be going. So it's actually identifying very accurately what the market value of the property is by requiring them to go into the marketplace through a court. The other thing that the not-for-profit bodies need is money. And again, if you look at the European system, you have dozens of housing cooperatives in England who raise money on the local funds bond market. You've got the German systems; they also have access to banking funds there. There's a good return for banks in cooperative housing, and we've never tapped into that in this country. We have a number of housing associations doing extremely good work, extremely professional and good work in the cost rental model. But as regards cooperative housing, that's to say where the actual building belongs to the tenants, we haven't done that, and there's a reason for it actually. If you think about it back, there's a reason why we don't have, if you like, a history of cooperative housing in this country, and it's because the entire country was a cooperative. That's how we started the state. It was, let's all dig in here and do stuff. And so we never had to develop individual cooperatives, and they never developed, of course. But the perfect opportunity was there when I proposed the National Housing Cooperative, and that bill went off to the powers that be, and the powers that be came back and said, "What's this section here?" They said, where it says the Taoiseach will set up a cooperative. And the answer was, well, it's there because to establish its national identity and its credentials and its public weight behind it. And they said, oh no, we couldn't have that. They said, no, well, the Department of...
But I mean, doesn't it go back, Edmund, to the same problem time again? I mean, there's no end of really interesting solutions. We do things. Why don't we do things differently in Ireland? We've been doing them the same way since the foundation of the state. You know, we've had periods of glimmers of hope along the way, but generally we keep going back to the default position of getting it wrong. But I mean, you know, we apparently have 200,000 residential units that are empty. There are 10,000 people homeless in the country and at least 10,000 empty bedrooms in the Dublin local authority housing stock alone. 10,000 empty bedrooms in local authority housing stock in the 4 councils in Dublin. With a bit of imagination, Owen Harris could solve this problem quite easily if he wasn't out taking selfies of himself with Varadkar and Harris, the other. You know, I mean, this...
I think you said Owen Harris, but I don't think he has Owen Murphy.
Owen Murphy. I confuse the three of them at this stage because, you know, I mean, it is not a difficult thing to solve.
We have a history here of getting committees to produce reports and saying, you know, these look like good ideas. But from the politician's point of view, if the work has been done and the proposal is there on the table, he looks at it and says, where are the votes in this for me? Will I hold my job? And then if he goes to the department and says, I think we should make a radical change here, the department will say, you know, like in Yes Minister, they say, oh yeah, that's very courageous, Minister. and they simply will find ways of ensuring that the great plan is watered down, delayed, spancelled in some way. Why is that? That's the issue. I don't personally think it's a corruption issue, unless you regard, if you like, the state servants as being corrupt in a small sense by anxious to maintain the status quo. That seems to me to be the problem, that we don't have a public service which you can kickstart. I mean, you can kick, but it doesn't kickstart into making changes. I mean,
I mean, it's either corruption or it's just mismanagement. And the reason I keep saying that the system is corrupt, because I believe the abuse of taxpayers' money is an act of corruption. And we're seeing that day in, day out. But the fact that they won't bend to new ideas, like, for example, your legislation, they won't bend to it at all. They won't entertain doing things differently, looking at what's happening in the rest of Europe, new ideas, looking at the housing stock that is empty and saying, no, come on, let's have a look at this housing stock. Let's find out why is it empty and what can we do to fill it. They don't want to entertain that. So to me, that is corruption.
Okay, but I must say I'm a little bit more optimistic about my bill than you are. But there's always the financial problem. That's to say, the Maastricht Treaty and the budgetary requirements. How do we spend our money? Do we have any extra money to spend? And the only way of getting money into the housing area is by accessing international funds, ethical funding, low-cost funding from America and elsewhere, which is available for specific housing needs, social housing needs. That seems to me. I mean, what they did was in the NAMA situation was they got in the commercial money, the big money there, and instead then of developing that and saying let's now get in some friendlier form of finance to meet the housing problem, they said, oh, well, here, let the vulture funds at it. Actually, the history is quite interesting. I know maybe we haven't got time, but the banks in general were very amenable to a social solution to the problem. They started off by holding back and said, we're quite happy with the moratorium. And then after that, then they started kicking the can down the road. Don't know whether you remember that. The kicking the can down the road proposals. Mm-hmm. After that, then the government said, well, we better set up a committee to work out where we should be going with this. And that took a year to report. And meantime, the banks did nothing. So the banks sat on these home loans on their portfolios for a long time. And up to the point where now what they're saying is it's the ECB is now telling us we have to get off the fence here and sell them on. Personally, I think that the banks were never properly, if you like, involved in trying to work out how they could absorb the losses that had occurred on these mortgages. And I'm not sure that anybody really knows, down to the last T, where these losses occurred. Why did people fall into arrears? Because the people who talk about strategic default think that anybody who's in arrears must have done it deliberately. And they've forgotten what happened in 2008. They've forgotten the number of people who lost their jobs and the collapse in the economy at that time. And I think people actually, at that time, many people just simply were unable to, or made a decision to feed their children rather than paying the mortgage, and took, if you like, a mortgage holiday from which they were never able to recover. Now, you're right if you say, well, that's a bad thing for banking generally, that people would think that they could actually ignore their obligations in that regard and not suffer any consequences. But I suppose where I got most agitated was with the fact that the banks were, if you like, insisting on the last penny when it was they who actually collectively caused the problem in the first place.
And nobody ever put manners on them. And,
no.
It's a bit like with the Gardaí, they will continue to engage in scandal after scandal because there's nobody minding them from themselves, nobody saving them from themselves.
This is the law of finance. And I brought this in because it's quite interesting. Towards the end of the book, which is an academic book, he says, The Roots of the Crisis. He says, the financial crisis began with fraud. It grew into international financial panic through collateralized debt obligation and credit default swap markets only later. And then he goes on to say, probably the best investigative accounts of the roots of the financial crisis is in a book called The Monster, which identifies the roots of the mis-selling of subprime mortgages. I was going to tackle the American professor about this as well. He says, the author's account begins with the account of Mark Glover, who worked at AmeriQuest Mortgage, who, quote, he looked up from his cubicle and saw a co-worker do something odd. The guy stood at his desk on the 23rd floor. He placed 2 sheets of paper at the window. Then he used the light streaming through the window to trace something from one piece of paper to another, somebody's signature. And that was the root of the problem in America.
Absolutely.
We suffered the tsunami as a result of that.
But let's bring it back to, tonight in Ireland, there are people watching us now who are being faced with eviction. I mean, this is a horror. This is a nightmare for people who are in hostels and hotels tonight, and through no fault of their own. What can be done? I mean, working within the corrupt system with politicians who have no compassion. What would you say to those people?
Well, the policy of all the parties is to keep families in their homes, that repossession should be a last resort. And the bill that I've prepared is to give effect to that policy. And they need to wake up and say, more can be done to achieve the objective of the policy than is being done at present. And
but I mean, your bill is not likely to be brought into law, realistically.
But there is a general election coming up,
Yes, there is, and I mean, I'm sure it should be brought in. In fact, it may not even be needed if the right people are elected. But in the short term, have you any advice for people?
Oh yeah, wait, hang in there.
Keep fighting the banks, would you say? I mean, what are the tricks of the trade that you would say, okay, try this, this has worked, this has worked? What would you say to people?
I can't really be giving advice because I have to make decisions on their cases. But in relation to tenants who get letters from a company which is supposedly acting on behalf of the new landlord, they should not pack their bags and leave. They should sit and wait and see what happens. At the end of the day, people should be aware of the fact that there is human rights law there, which may be of some assistance in dealing with the most serious cases of eviction. There are cases from Croatia and Bulgaria and places like that where people have been, elderly people especially. There's one case I came across some time ago where an elderly lady came back to find she had been, her door, the locks had been changed. It was a local authority house. And she went to court, and the court said, reached the conclusion that because she was 83 years of age, her next move was the street, and she was facing early demise. And they said, there's no way that this is a proportionate response to the need of the local authority to recover the property. Now, translate that sort of balanced approach into dealing with a vulture fund. So if you've got a vulture fund who wants to evict somebody, and that person can say, I can pay X pounds, X euros a month by way of rent. The question then from the court's point of view must be, how much did the vulture fund pay for it? Because the vulture fund has its own financial costs. And if it gets a reasonable return on its investment, there's the proportionate solution. There's no way that a windfall for the vulture fund is proportionate if a person can pay the rent. So these are arguments that are being formulated. We don't have a particularly active legal system that's developing these. They tend to come in fits and starts. But I have been what do we say, stringing the people along for several years now, and in fact, in a sort of way, the rise in the house price market has enabled people to engineer their own exits from their problems. If the house prices hadn't risen as they have done, and that's not a good thing either, we would have a lot more repossession going on. So you're
saying that people are selling, they're finding they're able to get out of negative equity and are able to sell and not be left in.
Yeah. Well, also they're able to offer banks a reasonable return. Banks are also taking a more broad view of what is recoverable and what isn't recoverable. I mean, the whole point about a mortgage is, and I said it right back in 2008, I said it is in fact a joint venture between the borrower and the bank. Now the bank might say, "Oh no, it's nothing to do with us," but they are taking a risk, and they're not allowed, as a matter of law, to impose that risk solely on the borrower. So if you had, say, Bank of Scotland, Ireland, when they started, they upset the apple cart in the system by offering 100% loans plus furniture, you know. So there was no risk there. They had built in no buffer to cover for risk. And as far back as the 1960s, in England, they looked at this. The Crowther Committee looked at credit in England and realised that credit was now a mass phenomenon. It wasn't simply for businesses, and they looked very much more carefully on how risks of default should be spread across society. This is a completely different approach. It's a holistic approach to debt. And again, it annoys me because our own Law Reform Commission produced a report, 2008, in which they analysed the situation about secure debt. Let's see, I marked a passage here, see if I can find it. Oh yeah, this is what's interesting about it is...
That's a great answer, your favourite TD.
This is the consultation paper, and there's a section in it on page 28. It's headed Irresponsible Lending. As mentioned above, a sound credit agreement requires appropriately responsible conduct on the part of both the creditor and debtor. In a highly competitive credit market, the most profitable customers may also be those who carry the greatest risk for lenders. And so on and so forth. There's quite a few pages here about irresponsible lending. Conclusions. This analysis indicates that the reasons why debt go unpaid and why the enforcement system of courts is required are many and varied. And go on to spend debtors who cannot pay and debtors who refuse to pay. The importance of this distinction, so on and so forth. We're 10 years later. Well, do you know what happened to this consultation paper? There was consultation, and they issued a final report, and there was nothing in it about irresponsible lending.
Well, nor would there have been. I mean,
it was overlooked, you know.
So we're basically moving the deck chairs on the Titanic, really. Ed, I mean,
it's all there, you know. It's an insolvency problem, and you solve it through insolvency processes. One of which is to keep people in their homes, because on a cost-benefit analysis, that's the cheapest outcome for the state.
And I know from having been in your court that is really what you are trying to do every day. And people are very lucky to come before you. I suspect that's why you have so many cases coming out of the circuit court, because people know that they will get some sort of a hearing and advice from you and compassion when they're facing this absolute nightmare. But I'm conscious that we've been talking for about an hour now. I mean, really, Edmund, you're a pariah within your own profession. Because you've spoken out on the side of the citizen. I mean, I've no doubt that plenty within the legal profession secretly really admire you and would love to be able to speak out on behalf of taxpayers, on behalf of the people who paid for their education, and on behalf of the people who they're supposed to be representing, the citizens of Ireland. But yet the legal profession, like my own profession, are quite happy by and large to keep their mouths shut and allow the carnage to continue.
Okay.
I have to applaud you.
I have to say something. It's quite interesting. When you get appointed a judge, which I'm not, but anyway, you get appointed a judge, you throw away the chance to do anything, except in those cases that come before you. So you're very limited in what you can sit back afterwards and look across your life's work, because it's only those cases that came before you that you can actually do something with. Now, the Supreme Court has not very long ago said that if the government wants to do something about codes of conduct for mortgage arrears, and codes of conduct for consumers of this sort, codes of conduct for, regulation, in other words, under a state body, it's for the Oireachtas to legislate. They've said that. So they're saying, we've done as much as we can do, but they're setting out a broad hint that they want the legislature to legislate so that the matter can be progressed beyond the current legal situation. And that seems to have passed over the heads of the Minister for Justice and the Taoiseach. So there's no new legislation promised, apart from Michael McGrath's bill, which in its own way is a start, because it introduces regulation for the intermediate credit managers. And that's going to be quite interesting, actually, because there's a whole range of behaviours on the part of debt enforcers, if I can put it that way, that are going to come under scrutiny in terms of compliance with the European Directive on consumer lending and all of that stuff. The whole thing is an area of developing law. And if more people had money to litigate, we might develop it faster.
But that's not I don't believe that is the solution. I mean, you know, we're in an emergency situation now, and the charade and circus that goes on in the Dáil every day, I mean, it's beyond insulting. It's not getting answers for the people. You know, justice delayed is justice denied. And children's lives, 4,000 of them, at least 4,000 children, 4,000 childhoods are being destroyed, because these children are growing up without the security of a roof over their head. So shame on all of the Dáil. And I include, and I don't like to say this, but I include John McGuinness in this, somebody I consider a friend, because he continues to stay with a party who have brought us into this mess and will continue to allow the mess to continue as they prop up Fine Gael. The game is over now. These people need to get up and walk out of their seats. And we need a situation, as is evolving in Spain, France, and Italy, where citizens are saying no more, no more. And I'm not talking about the nonsensical protests that happened on Saturday, which seem to have been orchestrated by parties of the hard left, who are in favour of the decimation of our national sovereignty. I'm talking about what is happening in France. And these are the real working people, you know, the people who are at the coalface of austerity and who really are saying, that's it, we're not playing this game anymore, because we are the ones who are penalised every time.
The pity is that in relation to home loans, in relation to families with mortgages, that we don't actually have enough information about who they are, and they're not coming forward. They don't come forward and say, I put my name on that list, I'm in arrears as well. They eventually emerge into the court system, you know, somewhat sheepishly, and say, you know, sorry, I missed the circuit court, or I misread something, and here I am. I buried my head in the sand. And so the government really doesn't know how serious the situation is, because they're not getting the full picture on a daily basis or on a weekly basis. They're only getting the tip of the iceberg. And I think they're saying, well, sure, another few months of this, it won't matter much, and we'll get past the election, then we'll look at it again.
Well, I mean, I'd love to agree with you on that, but I don't believe that's the case. All they have to do is, they know fine well, all they need to do is go into your court any day of the week. I mean, they know, but they don't have any compassion. They're only interested in serving their parties and themselves.
There's a rather interesting thing which occurred, which I can't really understand, and that is that when they, as I said to you, the cases were all transferred back to the circuit court, and the circuit court introduced a new rule to manage the cases, and a new type of summons for it. And the president of the circuit court at the time issued a directive saying that that the solicitors for the banks should write to the borrowers, the defendants, and say, dear defendant, you need not attend court. Right? You need not attend court. This case will be adjourned for 3 months. Now, of course, anybody who's in dire straits gets a letter saying you need not attend court, says, yoo-hoo! There's no way I'm going anywhere near the court. Nobody will recognize me. I don't have to show my face. But that introduced the notion that they could avoid going to court. And the result of that was the journalists began writing saying, oh, well, sure, 70% of them didn't turn up. And so everybody else drew the conclusion that 70% of them were strategic defaulters. So we have this is mismanagement of information, you know. Yeah. There's a reason for it, and it's not getting through to the people who make the decisions.
And it's all part of the strategy to mislead, to cast aspersions on people who are losing their homes, to, you know, muddy the waters, really, isn't it?
Yeah.
It seems to be. Edmund, how do you, and I will finish up now shortly, but I mean, like the stress that you must be under when you go into your court every day and see the agony that so many people are in, and, you know, it's all so unnecessary, really. How do you, it must be deeply frustrating for you.
Well, if you come to my court, you'll find I do crack jokes from time to time to relieve the stress, because that's all you can do. And I often deal with people, the lay litigants, and, you know, they come up to me, come up beside me here, you know, 3 or 4 feet away, as if they were the accused, you know, just talking. And sometimes the wife is standing beside him, and she says, go on, say it, you know. And it's you have to understand how stressful this is. And one of the things that I find with many cases is that they say, I'll say, well, I try and relieve the stress. I'll say, well, how long have you been in the house? And how did it come to this, and so on. And then I'll say, and what about, is there anybody else in the house? And they say, oh yeah, we have 3 kids now. There's one at college, and one, you know, and so on and so forth. And I will point out to them that anybody aged 18 and upwards should be there as a defendant in his or her own right. And if they're not there as a defendant, they can't be evicted. So that's that usually causes great confusion. And these things need to be pointed out. It's not up to me to point them out, but nevertheless, when you do get the information in court, there is an obligation on you as a judge, pseudo judge, to ensure that no outcome is produced which is in breach of the European Convention on Human Rights. And one outcome that would be produced is if somebody is evicted, an 18-year-old or a 19-year-old who's going to college and she's evicted, that's in breach of human rights. So these are the sorts of things that...
And have you tested that here, though?
Oh, all I do is I pass on the information. The banks, I think, try and you know, settle cases and so on. So if they find a really good case, the banks, which the banks find are going to be, they're going to have difficulty with, they'll settle. So it never gets beyond that point, and it's not then used as a general principle or precedent for other cases.
Sure. Yes. Yeah. Yeah. Well done on, you know, taking a stand against the banks. You're one of the few members of the, dare I say it, establishment that is doing that, and you certainly seem to be on the side of the citizen. And I'm not saying that you're not administering justice fairly, but I would suggest to anyone to take a trip into your court. I don't want, I mean, the numbers in there, it's absolutely packed, I suspect, most days, but you really would have to have a heart of stone not to feel tremendous sympathy for most of the people coming before your court. And it's so demeaning, it's so degrading for people to have to go in and fight for the roof over their heads, their home, the place where they've reared their children. It's hard to believe. We've learned nothing from our history, from what I can see, Ed. But on that very positive note, unless there's anything else you would like to add finally, Ed.
Yes, I don't make orders for eviction. In case anybody thinks that, I don't make those orders. I pass them on to the High Court judge downstairs. They may or may not be successful in the appeal. So,
yes, you're sort of a stopgap, really, aren't you? Too.
But it's still stressful.
Of course it is. Of course it is. And it would be great if you had more support from your colleagues, maybe in the circuit court, so that you weren't having to face these dreadful cases and deal with so many cases. But
it's not just the circuit court. Unfortunately, we now have High Court judgments which are at odds with one another. It seems to be at 6s and 7s in the High Court about a lot of technical matters which arise in these cases, which lay litigants are unable to understand or even grasp. So this is...
Well, I mean, I cannot keep up with the volume of people coming to me saying that they have major issues with their solicitors, barristers, judgments, the courts in general. And, you know, I mean, I'm certainly not an expert and I can't give them. And they ask me, who can we go to? Do you know any good lawyer who will help us? And, you know, I mean, I myself, when I found myself in need of legal assistance, I had to go to Northern Ireland to get a law firm. So it's just a very, very sad state of affairs that we're churning out all of these lawyers from our universities, taxpayer-funded educations, and they don't seem to be there for citizens. Well, but you are. You are. So, Edmund, many, many thanks again. And I do hope that we will talk again. Keep up the great work, and hopefully a change of government will certainly, produce some good results and bring an end to this housing crisis, because I can't really see another solution at the moment. Good evening, Ed, and we'll talk again soon.
Thank you very much.
Thank you. Thank you very much to everyone for tuning in. We've had a great viewership this evening. We will continue. Later this week, I will be discussing corruption within the United Nations, and looking particularly at the cover-up of sex scandals within that organisation, as we prepare in the coming days to hand over responsibility for our borders to the United Nations as part of the Global Compact, which will be signed in Marrakesh by Leo Varadkar and Fine Gael in later in this month, and in the coming days, actually. This migration pact, I believe, is going to be disastrous for our country, for our national sovereignty, and it will also be the case that even to speak about mass immigration will be subject to penalty. So this is a subject that people need to waken up to. It's coming down the tracks at a rate of knots. And as we know, the United Nations is an unelected bureaucracy. And the idea that our borders, responsibility for our borders will be handed over to the UN effectively is a matter of concern for all citizens. So I hope you'll tune in to my live streams. I'll be giving you details as to when we'll be doing that. I'll also be discussing the matter of abortion regret, which has been very controversial of late, and that will be later in the week. So for this evening, thanks again for tuning in, and I'll talk to you later in the week. Goodbye.